Okay, thanks for joining us tonight, folks. We appreciate you attending and taking the time to watch this informative presentation that is going to be done by some students, law students at Western Law. We have Neely Jarvis, Marissa Fowler, and Chanel Ryu McCormick, who will be talking about spousal support and notice of recalculation of child support. They've been working hard on the presentation. It will be, like I said, very informative, thorough. There will be a question answer period after, to which I can answer your general questions with respect to the law, and I can give you general advice. What I cannot do is give you specific advice about say if you're in court, your specific case, or your specific issue that you may be dealing with at this time. Keep in mind, if you do ask any particular questions with detail, there is no confidentiality here. This is a public forum and it will be on YouTube. So I would caution you to disclose any private information. Just keep your questions general, and I'll try to answer them the best that I can. Keep your questions to the issues that we've talked about. I cannot answer any questions with respect to property, equalization of net family property or anything like that. So I just wanted to get that out of the way. But if there's nothing further from me, I'm going to let Chanel take it away. Okay. Thank you.
Thanks for that, Greg. Before we get started today, I just wanted to provide a land acknowledgement. We acknowledge that Western University is located on the traditional lands of the Anishinaabe, Haudenosaunee, Unapanuak, and Aratanwaron peoples on lands connected with the London Township and Sombra Treaties of 1796 and the Dishwith-One-Spoon Covenant Wampum. This land continues to be home to diverse Indigenous peoples, such as First Nations, Métis, and Inuit, whom we recognize as contemporary stewards of the land and vital contributors of our society. So we'll get started on the presentation now. Let me just share my screen. Here, so I'm gonna start. That looks pretty good. And I'm so sorry, just let me get sorted quickly. Okay, perfect. So I think everyone can probably see the title page here, so I'll just get started. So hi, everyone. Thank you for joining us today. My name's Chanel, and I'm joined today by two of my fellow caseworkers at Community Legal Services, Marissa and Neely, as well as our resident family law expert, Greg Perrick. Marissa, Neely, and I are going to start off on a brief presentation on how you can utilize the online child support service to update your child support through a notice of recalculation. Then I'm going to give a brief overview of what motions to changes are and what they might entail, which will include decision-making and parenting time, special or extraordinary expenses, and spousal support. At the end of our presentation, we'll reserve a little bit of time so that Greg can answer any questions you may have. So let's start with the online child support service. We're going to be looking at what it is, how the notice of recalculation is enforced, who can use the service, what documents you might need, and then the next steps that you might want to take if you don't qualify for the service. So what is the child support service? Well, essentially, it's a government tool that works with the Family Responsibility Office to keep your child support updated without you having to go to court. So it only covers the table amount of child support, which is the table amount is considered the minimal amount of child support that the government will mandate you to pay per child based on your income. In some situations, the service can also be updated to include certain special or extraordinary expenses. Those expenses pertain to health expenses or medical or dental insurance premiums, but you can only request this if both you and your partner agree to it. There's also an $80 fee to use the service, but it'll accept fee waivers as well. So if you're either a legal aid recipient or if most of your income comes from social assistance programs like Ontario Works, for example, or the Ontario Disability Program, then you'll probably qualify for a fee waiver, which means that you don't have to pay the $80 fee. So why would you need to update your child support? Well, in most cases, because the parent paying child support has had a change in income. And the reality is that in real life, people's jobs change all the time, and unexpected circumstances might arise where someone might lose their job for whatever reason, or they might get a promotion and make a lot more money than what they were making during the original court order. And when those things happen, then the child support that you're receiving is no longer an accurate amount of what you're actually entitled to. And this is why the service has become available. So here you can see an image of the Welcome portal. You can easily access it online. You just have to Google child support service. It'll be one of the first searches that you'll see. And then you just have to click apply here. So how does it work? Well, the service will use the updated income information that you provide to send what is called a notice of recalculation to your partner. And that will detail which children the support is for and what special expenses you're asking for. Then the partner receiving the notice of recalculation will have 25 calendar days to reply with their income information. So normally that's in the form of either a notice of assessments or your 3 most recent pay stubs. Or if the most of your income is from social assistance programs like ODSP, then you would include that as well. This is considered a binding notice. So that means that you have to follow it like it's a court order. What that means is your partner can't just ignore a notice of recalculation without consequences. And the service might actually use the information that the partner uses that they've provided. So once they've replied, you'll get another notice which will show how much child support will need to be paid. So either parent will then have 15 calendar days to request a change if they think that the calculation has been inaccurate. So the notice is also sent to the Family Responsibility Office, and it's through that organization that will enforce the notice. So in case you aren't familiar with it, the Family Responsibility Office, which we refer to as FRO quite often, is a government agency that acts as essentially middleman between you and your partner to keep track of how much child support is being paid and what the paying parent might owe in arrears if they're underpaying child support. So if the paying parent isn't paying child support or they're underpaying child support, FRO can call their employer and ask to request that a portion of their wages be deducted for child support. They can garnish your bank account, they can suspend your driver's licenses, or they can actually take you to court with possible jail time. These consequences are serious, but that's also because child support is considered to be the right of the child, and it's within their right to receive a certain amount of compensation per month to support their essential needs. But all in all, if you can use the service, it's a pretty effective tool in making sure that your child support is being paid. So who can use this service? Basically, in order to access the service, you need either to have a court order detailing child support or a separation agreement that's been filed with the court. If you've received a notice of calculation or recalculation, that generally means that you either have a court order or separation agreement, and then you can use the service for that as well. You'll also need to have an account set up through FRO. Normally, this is pretty standard in most court orders, but if for whatever reason you don't have a FRO account and aren't receiving child support through FRO, you can always request for an account to be opened for you. Your partner can't prevent you from opening an account, even if they don't agree, even if you've had a prior agreement that you wouldn't go through FRO. There only needs to be one consenting party to open an account, and then they will do it for you. So in order to use the service, you have to have your court order separation agreement and your FRO account set up. And then in order to update your child support through this service, you can only do it if you're asking for the base table amount and only if your court order, so the original one, provided the base table amount as well. Everyone has to be living in Ontario, so that includes yourself, your partner, and your children, and your court order has to have been made in Ontario as well. You also can't request this service if your child is over the age of 17 and a half, and if they're married, because then they're not considered dependents under your care. And also, the paying parent can't earn what is called complex income, which means that the service really only deals with income that's pretty straightforward, such as if you have a set salary, for example, or hourly wage that can accurately be reflected on your tax returns or T4 statements. So complex income essentially means that the paying parent either earns less than $12,000 a year or more than $150,000 a year. If over 20% of their income comes from either self-employment, rental income, or seasonal jobs like landscaping, for example. Most of their income comes from being a director, partner, officer, or a majority shareholder in a company, so their income is in flux a lot of the times. Or if most of their income comes in cash, which is not reported on their income statements. So an example I like to give is a restaurant worker, for example. Servers tend to make a really low base hourly wage, but they also get a significant amount of their income through tips, which is considered cash that they then have to claim on their tax returns. So it's important to note that the service will not allow you to request retroactive child support, which means that if the partner has been underpaying child support for years, this might not be the best option for you because you'll only be able to claim the updated child support starting now. If you need to claim retroactive child support, then you might want to think of actually filing a motion to change with the court instead. You also can't use the service constantly because the service will make you wait at least 6 months between sending out notices. And the service is also pretty limited in what kinds of special or extraordinary expenses you can claim. So it'll only cover childcare expenses, medical or dental insurance premiums, or health-related concerns, and you won't be able to claim extracurriculars or educational expenses either, like private school fees, for example. Also, both parents have to agree on the amount claimed for the special expenses, which practically speaking often presents a barrier to using this service because a lot of times partners don't agree on how much expenses will cost each of them. So if you and your partner don't agree on the special expenses claims, or if they don't fall under the child care or health expenses criteria, then you might also want to file a motion to change with the court. Saying all that, if it's sounding like you might qualify for the child support service, make sure that you have your court order or separation agreement handy for uploading, or a copy of the notices of either calculation or recalculation if you've received one. You also need your SIN number and a current mailing address for your partner. And if you're the paying parent, be prepared to either upload last year's notice of assessment, or if for whatever reason you don't have one, then just upload the 3 most recent pay stubs from your place of employment, or any other form of income you might be receiving, like Ontario Works or DSP. But as you might have gathered, the application of the service can be quite specific. But if it applies to your situation, it's a really great tool to utilize. But there might be other changes that you need to make to your current court order or separation agreement, be they things like decision-making and parenting time, a retroactive child support, special expenses, and spousal support. So if you're looking to change these, you're going to have to file a motion to change with the court. Which now leads us to motions to change. So we're now switching gears to talk about motions to change, and they're otherwise known as Form 15 if you're looking to download one online. So I'll provide a brief definition of what a motion to change is, along with what decision-making and parenting time mean. Neely and Marissa will then explain the special expenses and spousal support. So in their essence, motions to change are like requests that to the court to modify your existing court orders or separation agreements so that they best reflect you and your child's current situation. So when filing a motion to change, you need to show the court that there's been a material change in circumstances in order to support the modifications you're seeking for your court order. A material change in circumstances means that you and your child's situation has changed to the extent that your current court order is outdated to properly meet the needs of your current situation. So things come up all the time that force you to have to reassess your parenting regime, and new expenses come up all the time too. So like sending your kids to a certain school, like private school, for example, or your child now needs braces, so orthodontics is a big one. New medical conditions can come up. Or sometimes the parenting regime starts as shared parenting time. So we'll say your child's with you for 1 week and then they're with your partner for another week. But now it's changed to the point where your children primarily reside with only one parent. So all of these things put together would make all those things separately would actually be considered a material change in circumstances. So this is just a picture, another screenshot of what a motion to change looks like. If you look at the top right corner, you'll see Form 15 motion to change. Just make sure that you have the proper form when you download. There are more pages than this, but this is just the front page for your reference. So decision-making and parenting time, which were formerly known as custody and access, are two pretty common things that are requested to be changed through a motion to change. But often they're not fully understood as to what they really mean. So decision-making was formerly known as custody, which essentially refers to the right to make major decisions about how to raise your child. So that includes stuff like education, medical care, religion, and other important extracurriculars. So we'll say like your child might be a hockey star, so that might be an important decision in their life. Decision-making can be shared, split, or given solely to one parent. So if it's shared, then both parents need to cooperate with each other in making the big decisions for their children, while a split decision-making regime might look a little bit more like one parent takes care of educational stuff, while the other parent decides on medical care. Sole decision-making refers to situations where it's only one parent that decides on the big decisions regarding their children. So it's really important to note that decision-making and parenting time are separate from each other. So having full decision-making or custody, having full decision-making known as custody doesn't mean that the other parent is not entitled to parenting time. Which then leads us to parenting time, which was also known as access. And that refers solely to the amount of time that the child will spend in the care of the parent after separation. So in the vast majority of situations, both parents will be entitled to some form of parenting time. And both parenting time and child support are considered the rights of the child, but they're also considered separate from one another. And that means that a parent won't be able to withhold parenting time, even if their partner isn't paying child support. So they can't say, you can't see our child because you're not paying me. That's not how it works. And that's because it's the child's right to have a meaningful relationship with both parents. Okay, great. And now I'm going to pass it over to Neely to talk about the special and extraordinary expenses.
Great, thank you, Chanel. So special or extraordinary expenses are childcare expenses that are not included in the basic monthly amounts of child support. And these expenses are also known as Section 7 expenses. Special or extraordinary expenses are additional or extra expenses that are not covered in the normal table amount. And these expenses may include childcare fees, such as daycare to allow the parent who looks after the child to go to work or school, the part of medical and dental insurance premiums that the other parent pays to cover their child, the child's healthcare expenses such as orthodontics, prescriptions, or eyeglasses, to name a few examples, reasonable and extraordinary expenses for school or educational programs to meet the child's particular needs, such as tutors or private school fees, as Chanel mentioned earlier, expenses for post-secondary education, and finally, some reasonable extraordinary expenses for the child's extracurricular activities, such as competitive sports classes. So firstly, these expenses must be reasonable and necessary, and we will go through these requirements on the following slides. There's no checklist to determine if an expense is special or extraordinary. Rather, every expense is based on your family's direct financial situation. You and your partner can determine if an expense is special or extraordinary in your circumstances. In most cases, both parents help pay for their child's special expenses based on their respective income. If you and your partner make roughly the same amount of money, you would divide the cost of special expenses equally. All right, so first of all, we're going to look at whether or not a special or extraordinary expense is reasonable. So to begin, if the parent's asking for special or extraordinary expenses, you must demonstrate that the expense is reasonable. When deciding if an expense is reasonable, the court will look at your family's financial situation, and this may include both incomes, basic amounts of monthly child support, the number of extracurricular programs that your child engages in, and the total cost of extracurricular programs. And then finally, whether such expenses reflect your family's spending patterns prior to separation. Regardless of prior spending patterns, the court may allow the expense if it's in your child's best interest and you and your partner are able to afford it. Essentially, the court is just seeking to determine whether or not you and your partner can afford the cost at that time. Next, if you are the parent asking for special or extraordinary expenses, you must show that the expense is necessary. And this essentially means that the expense is in the best interest of your child, whether that be because they have a special talent or maybe they require additional help. So an example would be if your child was a talented swimmer, it might be in their best interest to attend competitive swimming lessons. Conversely, if your child requires extra help in mathematics, it might be in their best interest to hire a tutor. If you personally want your partner to share the special or extraordinary expense, a child must be a dependent. Typically, this means that the child, until the child turns 18. However, there are certain circumstances where this can last longer. A child is not dependent if they have married or if they are at least 16 years old and leave home. And this is referred to as voluntarily withdrawing from parental control. However, withdrawal from parental control means that your child decides not to live with you anymore and not to follow your rules on their own. Withdrawal from parental control has to be voluntary, so they cannot be forced to leave. If a child is kicked out or forced to leave, then this withdrawal will not count as voluntary withdrawal. As mentioned previously, a dependent typically means until the child turns 18. However, children who are over the age of majority, so 18 years old or older, may still be dependent if they cannot support themselves because they have a disability or chronic illness or they are attending post-secondary school. In the case of disability or chronic illness, a child may remain dependent for their entire life. And in the case of post-secondary students, it's generally accepted that a child who is completing their undergraduate degree is in need of support until they finish school. The child must be studying and not just enrolled in the program. And sometimes support can be ordered to allow the child to get more than one degree. If a judge finds that a child over the age of majority should receive child support, they can order the table amount or something different. And the child may also have to contribute in these circumstances. Moving forward, we'll consider the division of expenses. In most cases, both parents share the cost of special or extraordinary expenses based on their respective income. You and your partner can also agree to share the expense in a different way. If your child is 18 plus and they're still a dependent, they might also have to contribute to their special expenses. And if so, this amount is subtracted before the parents divide that expense. And then finally, prior to dividing any special or extraordinary expenses, it's crucial that you and your partner share honest and complete information about your income. This information can be shared in a variety of ways. As an example, a computer spreadsheet, a handwritten document, or the financial statement court forms. One thing to remember is that a financial statement court form is a sworn document. So it's very important that you be as truthful as possible if you are going to use this form. Even if you do not go to court, this form can be useful as it shows what the court is looking for in support issues. The person asking for special or extraordinary expenses should also list each expense with an explanation, the total cost, the date that any payments are due, receipts, and any other relevant information. And now I'll pass it off to Marissa.
Thanks, Neely. So I'm going to be talking about spousal support today. So first off, I'll start by asking, what is spousal support? So spousal support is the money paid by one spouse to the other after they separate or divorce. And the law says that you are expected to try and support yourself, but sometimes you can get spousal support from your partner if they earn more than you do. And spousal support can be awarded in addition to child support. And while using the child support service, you must include other financial support, such as spousal support or child benefits. So the purpose of spousal support is to help a spouse become financially self-sufficient, prevent a spouse from experiencing serious financial difficulty due to the breakdown of the relationship, share the costs of caring for children, or compensate one spouse for being financially disadvantaged during the relationship. And when spousal support is ordered, it is paid by the spouse with the higher income to the spouse with the lower income. So for example, this could be awarded when one person stopped working to care for the children. And then you can move to, yeah, all right, perfect. So to be eligible for spousal support, it's not automatic, but you and your partner can try to reach an agreement about spousal support, or if you can't agree, you can get help from a family lawyer or go to court and ask a judge to decide. There are rules about spousal support and social assistance. Social assistance includes Ontario Works and the Ontario Disability Support Program. We'll be going into those today, but this could affect your eligibility for spousal support. So there are 3 ways to be entitled to spousal support, and more than one of them may apply. So that's compensatory support, non-compensatory or needs-based support, and contractual support. So for compensatory support, you would have the responsibilities during the relationship, such as taking care of your children or helping your partner build a career. Or needs-based support, the breakdown of your relationship leaves you in need of support and your partner has enough income and assets to pay support. Or contractual support, where you and your partner have a cohabitation agreement, marriage contract, or some other agreement that says if you separate, you will get child support. So in the first instance, oh, sorry. So in the first instance, I'll wait for you to go back.
I'm sorry, 1 second.
Okay.
Oh no, okay.
Okay, I'll just
we're going back, don't worry. Give me 2 seconds, I'm almost there. I thought we were so in sync.
We were doing so good.
There we go. Sorry, go ahead, Marissa.
So for the first one, compensatory support, for an example, it could be because of that you lost a chance to build your own career. The court looks at factors when looking at eligibility, such as how long you and your partner have lived together, if you have children together and who has been caring for them, each partner's income, each partner's overall financial situation. If you are entitled to spousal support, the law still expects you to try to support yourself as soon as possible after separation. And there are exceptions to spousal support. It is based on your situation, but some examples could be if the support payer makes less than $20,000 a year and paying support would push them into poverty. You have other family debts such as a mortgage. You're paying child or spousal support from other former partners, or the support payer is on disability, workers compensation, or cannot deduct part of their income because they work overseas. And there are other exceptions to this as well. But like I said, it is based on your situation. Okay, so setting up spousal support. So there are 3 ways to set up spousal support. 1, a separation agreement. 2, if you create your own separation agreement, you may file it with the court so the court can enforce the support terms of your agreement, or so the support payments can be enforced by the Family Responsibility Office. Or 3, you can bring your case to family law court and let a judge decide. This could result in a court order for spousal support that is enforceable by law. And then finally, we'll go into spousal support calculations. So the amount of spousal support and how long it is paid is dependent on several factors, such as how long you and your partner have lived together, if you have children together and who has been caring for them, each partner's income and age, the roles each partner had during the relationship, each partner's physical and mental health, and the ability of each partner to support themselves. And spousal support amounts are generally higher and paid longer where there are big differences between the partner's income, they have lived together for a long time, or they had children. Amounts are smaller if there are smaller differences between the parents' income and their relationships were shorter. And the courts use the spousal support advisory guidelines, or they're generally known as SSAGs, to help them decide how much spousal support should be paid and for how long. Steps to Justice has a free online calculator that can give you a rough idea of spousal support calculations, but it's not certain as this calculator is not law, and it only does simple calculations because it only takes employment income into account when there are many other factors to be considered.
Okay, great. Thank you for that, Marissa. I included some resources at the end as well. So Marissa mentioned Steps Suggested. Steps Suggested is a fantastic website to go on. If you have any questions at all about next steps, they break it down really easily for you. There's also the Community Legal Education of Ontario, so we call it CLEO. That is, I believe it's the parent website for Steps Suggested. So they're made by the same people. Steps Suggested is just a little bit easier to navigate. And if you're looking for virtual support, there are family law information centers located at every courthouse. There you can find legal information referrals. You can talk to duty counsel. You can get some information about separation, divorce, and child protection. You can have access to all the court forms as well, and information about the court processes, referrals to mediation, and then information about the mandatory information program. Not said on here, but if you also have a court date, there will be duty counsel there available to speak with you as well if you have any questions through that. So I will stop sharing my screen and then I will hand it over to Greg.
Thanks for that. You guys, that was very great and informative, so I appreciate that. So what we can do is we can open up for general questions. If you don't want to say it on video, you can put it in the chat. I think that's fully enabled. So if you want to drop a question in the chat, go for it. In the meantime, there's just a couple of things that I would follow up on, not to correct or clarify. The students did a fantastic job. One thing that I will say is we talked about the idea of a child withdrawing from parental control, right? And while that element is definitely an argument that one could make in court, but I would caution you generally, and I would encourage you to get further independent legal advice. Talk to a lawyer about that issue if that's something that may apply to you folks out there, because it is a very, very specific and very, very difficult argument to make. So, if any of you out there are having an estranged relationship with your child, and you think, well, maybe that's something that applies to me, I would strongly encourage you to speak with a lawyer about that at further length. Again, I can't give specific advice, but that's one thing that I would mention. Two, with respect to special and extraordinary expenses, we talked about, we gave some examples of that. That does not mean that those are the only examples. The list is not a complete list in any way. So if you think that your spouse or yourself are claiming some extra contribution to dance lessons or something like that, I really encourage you to, again, get independent legal advice to see if that's something that falls within special and extraordinary expenses or extraordinary expenses, because it's just not a given thing. So I just don't want you all to think that the examples that we gave are just the examples, and that's the end of the list. I really appreciated Chanel calling me a family law expert. I'm not an expert. That is something that it's a designation that we can't hold out ourselves as, but I do practice family law specifically. So I am entitled to and certified to give you general advice in this circumstance. But I just wanted to be clear on that. But I do appreciate that vote of confidence from Chanel. So those are the things that I wanted to say. If anybody has any questions, I can answer them generally as best as I can. If you don't have any questions, that's perfectly fine. Don't feel any pressure to do so. We, again, appreciate you coming out tonight, and we encourage you to tell others that we'll continue to be doing these public legal educations The next one, I believe, is April 12th. Somebody speak up if I have that day wrong. And we're going to be talking about removal of a child from a parent's care. And that speaks to Children's Aid Society issues. So, if you know somebody or yourself is experiencing that issue, I strongly encourage you to tell them about that and have a look out for our eventual advertisement. And it'll be just like this. You don't have any obligation to interact with us. You can just take in the information, and I think at the beginning I said we recorded it, so you can have a look at it after at your own time. We have a YouTube account. I called it a website earlier. It's not a website, obviously. It's a YouTube account. It's the Western Law account. So you could even hit that subscribe button and I get updates on that. So again, I'll wait probably a minute or two to see if anybody has any questions, but if you don't, have a good night. We appreciate you attending. Yes, go ahead.
Hello, everyone. Thank you very much for the very informative presentation. I would be appreciating, would be very grateful if the participants could fill out the feedback form, please, so we know that we are doing better.
Yeah, thank you for that, Mr. Karki. I wanted to make clear that we're in partnership with the Rights and Responsibilities Awareness Institute. They've helped us boost our signal, and we're happy to be working with them so that we can get this information out to the public. So thank you to them for that. We really appreciate it. And they do, and I will say that they do other public legal education. They're not legal education, but public education. So, stay attuned to that as well. And yeah, like Mr. Karki said, the form is in the chat if you want to fill that out. So I'll just give probably 30 seconds or so. We don't want some dead silence while we all just stare at each other. So if you have some questions, great. If you don't, that's great as well. And you're welcome to sign off, of course.
Thank you very much.
Thank you. Have a good night.
To you.